Have I ever changed my theory of liability, either during a deposition, pretrial testimony, or at the time of trial? You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is, during a deposition, yes I have. During a trial, absolutely never. Let me share with you what I'm talking about. Our theory of liability is what we believe the people whom you have sued did wrong. What did they do wrong? How were they careless? What did the doctor do to violate the basic standards of medical care, causing you harm and injury? That's our theory of liability. And you should know, in a medical malpractice case, I have to get a medical expert to confirm that there was wrongdoing, that the wrongdoing caused injury, and that the injury is significant and permanent. And I have to ask the doctor, what did this doctor do wrong? What should he have done? How would the outcome have been different? Would the patient still have received any of these injuries had the doctor done the right thing? That's our theory of liability. So now let me share with you a story involving a gentleman who went in for elective orthopedic surgery. And during the course of the anesthesiologist giving him the anesthesia in preparation for this surgery, this patient wound up going into cardiac arrest immediately after getting this injection. And now they had to spend 15 minutes reviving him. Thankfully, he survived. But then he was in the cardiac care unit for a number of days to try and figure out exactly what happened. And a review of this patient's medical records did not give the full picture. And it was only after we brought a lawsuit and after we went ahead and I began to question the doctor who did this procedure, the anesthesiologist, did I really learn exactly what happened. So now I went into this question and answer session, his pretrial testimony, where there's a court reporter present in the attorney's office. And the doctor is there, the anesthesiologist. And now I'm asking him questions about what he did and why. And it turns out he claims that there was no allergic reaction to this medication. That's not what caused my client to go into cardiac arrest. And as I'm questioning this doctor, he tells me, wait a second, your client did not have an allergic reaction to this medication. I said, wait a second. You knew my client was allergic to the medication. He said, no, I didn't. Went into pre-surgical testing. He told them that he had this allergy to lidocaine. You're telling me, as the anesthesiologist who's preparing him for surgery, that you didn't know that he had this allergy? If you knew that he had this allergy, wouldn't you have given him a different medication? Yes, I would. Wouldn't you have given him general anesthesia? Yes, I would. And if you had given him general anesthesia and put him to sleep, would you agree that none of this would have happened? Yes, I would. But that's not your theory of liability, he says. And he's right. Our theory of liability, based upon the records, based upon my discussion with my medical expert, who was a board-certified anesthesiologist, our theory of liability was that the anesthesiologist should have known that the patient was allergic to lidocaine and never should have given him this medication. But then the anesthesiologist turns around and says, wait a second. It wasn't the lidocaine that caused this man to go into cardiac arrest. I inadvertently put this medication directly into his bloodstream. And it should not have gone into his bloodstream. It was a mistake. I didn't mean for it to go into the bloodstream. That's cardiotoxic. That's what caused and triggered the immediate cardiac arrest, not an allergic reaction. So that was the one and only time that I had to change entire theories of liability during the course of this question and answer session. But even though I did, I turned it around on the doctor and I said, listen, had you known that he was allergic, you wouldn't have given him that injection, correct? Had you known he was allergic, you would have given him general anesthesia, yes. And had you done that, none of this would have happened. Isn't that true? Yes. And isn't it a fact, doctor, that a failure to recognize and understand that the patient was allergic to a particular medication would be a violation from the basic standards of medical care? True or false? And he had to say true. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding about one instance where I did have to change my theory of liability during the course of pretrial testimony when I was questioning a doctor in this medical malpractice case. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I do this every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.